after she had jumped out of the second floor window where she was, and her mouth had been bleeding on the ground, and he took a photo there. You heard from Officer Stebbins' body cam where you heard yourself, Brenda, stating, he, not he being the defendant, knocked my teeth out. That's State's Exhibit 4. That will be back in the jury room with you, where you can hear for yourself Brenda's own words. He knocked my teeth out. You have a defendant, a young man who is built. He is jacked. He is muscular. You mean to tell me a fit young man who is muscular like that, who comes barging into a bedroom door and attacks a woman who is innocently sleeping and curls up his hand and bashes it into her mouth, doesn't know what's going to happen when his fist meets her mouth? Of course he knows what's going to happen. He's going to cause her serious physical harm. He's going to bash out her teeth, and indeed that's what he did. As we saw in State's Exhibit 264, with her teeth laying on the ground, on the carpet, fallen out from the roots. And in fact, we saw from the coroner's photo as well, and I have covered up most everything except the teeth, but we saw her fractured teeth and her tooth sockets, where Dr. Schott testified and confirmed in her testimony that several of Brenda's teeth had been knocked out and others fractured. So did Robbie Robinson knowingly cause serious physical harm to Brenda Scott in the form of knocking her teeth out? Absolutely. Did the state prove that beyond a reasonable doubt? I submit to you, yes, the state did. And we would ask for a conviction on count 4. So let's move over to count 5. Did Robbie Robinson knowingly cause serious physical harm to Brenda Scott in the form of burns? Never mind that she passed away from the burns. Just did he cause her burns? Okay, again, Judge Spaeth will instruct you in the jury instructions. You can look at that just as its own count. Even if for some reason you don't believe she passed away from those burns, did he burn her? Okay? Submit to you, the state has proven that as well. You have heard State's Exhibit 3, that ring camera video from Dennis Williams, that 911 caller, the neighbor. The ring camera video says, you can hear her. Please listen to that back in the jury room. He set me on fire. He set me on fire. You can hear it. Now that initial sounds you can hear, those are Dennis Williams' dogs. But crank that volume up. You can hear her. He set me on fire. Then you transition to the 911 call because Dennis Williams goes running in on that night on the ring camera. He goes and he calls 911. And you can hear him saying what Brenda's telling him, said her boyfriend's son threw gas on her and set her on fire. His name is Robbie. He's 24 years old. He's still there. Listen to that 911 call. That is Exhibit 1. Then again, you go on over to Officer Stebbins' body cam, Exhibit 4. And we know he is still there, is the only one who is still in that house. He being the defendant. I submit to you, knowingly, remember, it's the same definition as when you knowingly bash someone's teeth out. Knowingly, when you are throwing ignitable liquids on somebody, and then you are taking a Bic lighter and you're flicking it on someone being Brenda, and you're catching their flesh on fire, you know what's going to happen. You're going to burn them. You're going to catch their flesh on fire. You're going to cause them serious physical harm. And And we're back to serious physical harm. And please note, I didn't even have to highlight one of the definitions. You only need one of the definitions, and she fell under all of them, right? Because when you burn somebody, they fall under all of those definitions. Any physical harm that carries a substantial risk of death. Well, she didn't have to die. She did. But substantial risk of death, she certainly fell under that one. Any physical harm that involves some permanent incapacity, we have that. Whether partial or total, or that involves some temporary substantial incapacity. Well, we know she was in the hospital for 29 days. Any physical harm that involves some permanent disfigurement or temporary serious disfigurement. We saw the autopsy photos. Any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. I think that goes without saying. Dr. Shaw testified that 60 to 69% of Brenda Scott's body suffered thermal cutaneous burns. Brenda suffered 29 days in the hospital until her death. Ladies and gentlemen, again, I submit the state has proven that Robbie Robinson knowingly caused serious physical harm to Brenda Scott with the burns. Just the burns. We are not even talking about death. We're just talking about burns right now. So that count 5, the felonious assault, has been proven to you beyond a reasonable doubt. So let's move on to counts 2 and 3. Now we're talking about the aggravated arsons, all right? So count 2 is of the person, Brenda Scott, and count 3 is of the structure, the house. Those are different definitions. Count 2, and I have them by comparison, then we'll break them down. Count 2, Robbie Robinson by means of fire, knowingly, there's that same knowingly, and it's the same definition, created a substantial risk of serious physical harm to Brenda Scott. Okay, so that's of the person, of Brenda. And then count 3 is of the structure. Robbie Robinson, by means of fire, knowingly caused physical harm to any occupied structure. So let's tackle count 3 first. Count 3, Robbie Robinson by means of fire. So fire is not defined. I think we all know what a fire is, right? Flame, fire. We don't have to define that one. Knowingly caused physical harm to any occupied structure. We already did knowingly, all right? It's the same slide. I just cut and pasted. It's the same definition. You'll be referred to that again in the jury instructions that says, hey, it's already been defined. He's aware that his conduct will probably cause a certain result. Cause. The state does have to prove to you that the defendant caused physical harm to the house, and that house was 2625 Arroyo Ridge Court. You will be told, that the cause is defined as an act that in a natural and continuous sequence directly produced the physical harm to property and without it would not have occurred. This one is, I feel, is important. Natural consequences. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences or result that followed in the ordinary course of events from the act. And the reason, and that's going to be in the jury instructions, but the reason I would like to emphasize that and why I stuck it or put it in the PowerPoint is this. Even if the original goal or the goal was to harm Brenda, period, the natural and foreseeable consequences of dousing Brenda and dousing the mattress and dousing the carpet and dousing the, I think I said mattress, but dousing everything in the close proximity ended up being causing a structure fire as well, causing damage to the structure. That's what happened. happens when you are dousing everything and anything and everything, even if your goal is to harm Brenda Scott. You are causing soot damage and smoke damage and all sorts of other damage to the structure. And that is natural consequences, natural and foreseeable consequences, okay? So even if your goal up here in your brain is to harm a person, you are also causing damage to a structure. And to me that is important because that is making you culpable and guilty of a structural damage. So if you could keep that in mind or maybe put a flag in the jury instructions when you're talking about the structure as well, because that is what is making the defendant culpable for the structure damage, for the aggravated arson of the structure. Physical harm, any tangible or intangible damage to the property that resulted in a loss to its value or interferes with its use or enjoyment. So we did not have to have the whole house in flames or burned down, okay? We heard Investigator Cunningham testify in his expert opinion. There was smoke damage, soot damage, and flame damage. We also heard Investigator Corwin testify to the same thing. And although in her role in this particular case, she acted as evidence technician, you also heard she is an expert, and in other cases she takes the lead. Just happened in this case she was the evidence technician, but they switch off. And she also saw the damage as well. An occupied structure, that really wasn't contested as well. Any house or any portion thereof, which at the time is occupied. We had a house. Obviously, senior lived there, the defendant lived there as well. It was a home. You heard from Investigator Cunningham again. He's a fire expert. He testified in his expert opinion. Based on the fire movement and the intensity patterns, there were two separate origins of fire events. Both were determined to be intentional human acts. One was the application of the ignitable liquid to Brenda, okay? We'll talk about that in count 2 when we get there in a moment. The liquid was also thrown on the bed and on the carpet and between the bed and the south wall, okay? Our structure. As well, when it was thrown on Brenda and it goes everywhere, that's our natural and foreseeable consequences. It's going everywhere and it's causing the damage to the structure as well, not just to Brenda, but everywhere, okay? So that's how we get to our structure. Brenda goes everywhere, throwing it everywhere else causes damage to the structure as well. So here, that's why we go into such depth, and we weren't just focusing on Brenda, although obviously she is the one who passed away and is the basis of our aggravated murder, but that is why you have photographs that focus in on the bottles here with the floor and the damage done, as well as the smoke and the soot. That is our damage to our structure in State's Exhibit 167, in State's Exhibit 169, the damage to the structure, in State's Exhibit 170. So did Robbie Robinson, by means of fire, knowingly cause physical harm to any structure? Yes. Was that proven beyond a reasonable doubt? Yes. The state submits that the state has proven count 3 beyond a reasonable doubt as well. And I'll just go ahead and put in there, you heard evidence of this random fire extinguisher being utilized up on the second floor. It was down at the end of the hallway, okay? But maybe there were some the fire extinguisher particles in the bedroom. Who knows why that was utilized? Maybe second thoughts after Brenda leapt out of the second floor to get away from the defendant. But it doesn't stop the fact that this defendant sitting right here started everything. He doused Brenda, he doused the mattress, he doused the floor, he doused the carpet. He started everything. He ignited everything, and he set fire to a human being. He set fire to the home, and it doesn't matter if he was like, oh goodness, and sprayed a tiny little fire extinguisher afterwards, after Brenda got the heck out of Dodge. That doesn't matter. He still is guilty of the aggravated arson. All right? So moving on to count 2. Aggravated arson of Brenda. All right? Robbie Robinson, by means of fire, knowingly created a substantial risk of serious physical harm to Brenda Scott. We're now into our count 2 of the person. Aggravated arson of the person. Knowingly. We've talked about it. It is the same, what we call mens rea, same thing of what's going on up here. What's he thinking about? Was he aware that his conduct will probably cause a certain result? Create a substantial risk. That will be defined for you again in the jury instructions. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Serious physical harm. This one, we don't have to look at all of those other definitions. This one is pretty simple. Serious physical harm in this case for Brenda Scott is death. She died. He set her on fire. She died. Is defendant acting knowingly? I submit to you, when you take a whole bunch of water bottles and you fill them up with ignitable liquids, and then you store them somewhere, and then you wait for your daddy to leave to go to work, and then you put on your clothes and your big puffer jacket in 70-some degree weather, and you're inside, and then you haul your little water bottles off down into a bedroom, and you go busting in, and then you bash out the teeth of your dad's fiance, and then you take those water bottles, and you start flinging the ignitable liquids all over the place onto Brenda Scott, your target, your victim, and then the mattress, and then the floor and the carpet, and then you take your lighter and you ignite the flesh of somebody, and the mattress, and everything else around her, that you're acting knowingly. It's not an accident. It's not like you're sleeping and your cigarette caught something on fire, or you were sleeping and you accidentally knocked over a candle and the candle caught a tablecloth on fire. You know what you're doing. You know what you're doing. You're utilizing a lighter that had your DNA and only your DNA on it. Everyone's used the lighter before. It's not a one-trick pony. For all those times, at least twice, because you had 2 different fire events, you had to have lit it twice, or it's one heck of a flame. Let's put it that way. And was it an accident? Well, you had a victim whose teeth were bashed out, some, who had to have had a struggle for her life and was still able to get out of that bedroom while her flesh was on fire, get into the bathroom whilst bleeding, knock out a window screen, get somehow up into the window frame, lower herself out of a second floor while leaving parts of her body or hair or something, whilst bleeding down the siding, falling down to a ground, and still be able to tell those who are helping her that she was hit and she was set on fire. Never did she say it was an accident or something else happened. and also while telling those who were trying to help her that it was that one right there who did it to her. Never saying it was an accident. So she proved ID. She proved that it was not an accident. Again, we had our fire expert come in here saying it was intentional acts, 2 fire incidents. And again, for the aggravated arson of the person, 1 was the application of an ignitable liquid onto Brenda Scott while she was in the bed. That is why we moved into evidence and had evidence of the mattress burnings as well. Can't see, but that's why we utilize State's Exhibits 166, the photographs of the mattress, 171, 173 with the pour markings down the mattress. That's why you saw the physical evidence of placard 3, item 3206, and item 4208, which are the parts of the bedding that had the ignitable liquids on it. Let's not forget her flesh. It was coming off of her outside. That was scooped up and taken as evidence that had the ignitable liquid. That was also found on the defendant's clothes. So was an aggravated arson of the person of Brenda Scott proven beyond a reasonable doubt as well? I submit to you that the state has proven that. Robbie Robinson, by means of fire, knowingly created a substantial risk of serious physical harm to Brenda. Yes. So we get to our final count. And the reason the state went in reverse order is because count 1 is predicated on the aggravated arsons. So we needed to talk about the aggravated arsons in order for aggravated murder to make sense. So for aggravated murder, Robbie Robinson purposely, now we have a different thought process, a different what we call the mens rea, purposely caused the death of Brenda Scott while committing or attempting to commit the offense of aggravated arson. So see how it makes sense to talk about the aggravated arson before we talk about aggravated murder? So Robbie Robinson purposely caused the death of Brenda Scott while committing the aggravated arson. Purpose. Now we have a little bit of difference. So far we've been talking about knowingly. What's purposely? Let's talk about purposely. A person acts purposely when it is his specific intention to cause a certain result. An aggravated arson. Was he trying to commit an aggravated arson? My argument is going to be similar to what I just argued to you, okay? But the definition and the jury instructions are different, and so I'm just trying to show you the difference in the mens rea. To do an act purposely is to do it intentionally, not accidentally. The purpose with which the defendant acted is known only to himself. There are different ways, and you will be instructed, there are different ways to determine purpose. Manner in which the act is done. The means used. All other facts and circumstances and evidence, and I want to stop here and note the yellow. Proof of motive is not required. I'm going to pause dramatically, right? Do you remember in voir dire when I made a big thing about, I think I asked if Judge Spaeth told you that the state had to prove A, B, C, and D, who here is going to make me have to prove A, B, C, D, and E? And I made you guys hold up your hands, and I don't think anybody did. The reason I did that is when we hear of a story I think our initial reaction is to say, well, why did that happen? I know I do it. We're curious. We're curious people. We want to know, why did that happen? Why did that person do that? Right? The state doesn't have to prove why. Let that sink in. We don't have to prove why. We have to prove, did it? Who did it? And did it happen? And we have to prove it beyond a reasonable doubt, but not why. The why is motive, okay? And the Ohio law says we don't have to prove the why. And sometimes that's hard. That's hard for people to understand, and that's why we talk about it in voir dire, right? And it's really important that you guys stick to what you said. You guys all promised me that you would not force me to prove a why, because I'm not sure we necessarily could prove a motive in this case. And in the jury instructions will say the state did not have to prove a motive. I got excited, hold on. I felt so strongly that I needed to do another slide on motive. All right?
Judge, can I check this case for a cycle real quick?
You may.
Thank you.
Excuse us, ladies and gentlemen, for just a moment.
While the state does not have to prove motive, we did hear the following facts at trial. You can take this or leave it. It's something to discuss in the jury room or not. Completely up to you. You did hear from the defendant's father, Robbie Robinson Sr. You did hear that the defendant was bound prior to meeting Ms. Brenda Scott, that the defendant was bouncing from home to home between mom and dad, that the relationship between the defendant and his father was stagnant, quote unquote, to use Senior's word, that the defendant just stayed in his room, defendant did not have a consistent job, that they talked every once in a while. I didn't write this in the slide, but that the defendant's car was taken away. the separation between the defendant and defendant's mom, affected the defendant. That separation happened in 2020. And then Senior met Ms. Brenda Scott. And then I submit to you, this is not Senior's words, the state submits to you that things went from bad to worse. Senior testified that he met Brenda in 2022, where they both worked at UC Westchester. Both of them worked as nurses. They started dating in May of 2022. They got engaged in April 2023. And plans were made for Brenda to move in to the home where Senior lived, to the home where the defendant lived. And within a month, Brenda was murdered. You heard that the morning of May 11th, 2023, Senior woke up while Brenda slept. She didn't have to work that morning. Senior did. Senior testified there were no bottles with ignitable liquid existed on his side of the bed. His side of the bed was on the side with the closet where the bottles ended up being. He got up, he went to the bathroom, picked up his clothes, that's where he got ready. There was no blood in the bathtub, as we saw in the scene photos. He kissed Brenda goodbye. She was fine. And he left Brenda and the defendant as the only two people left in that home. And the state submits to you that the defendant at that time literally bottled up his anger in the form of ignitable liquids. He put on his clothes and that big puffer jacket in 70+ degree weather, and that's when he attacked Brenda. He set her on fire. He set the house on fire. The state believes that some things you can use towards purpose are some of his statements that he used. And that's why the state played those statements, even though they sounded perhaps exculpatory. Compare that to the evidence that the state also provided to you. All of that has been moved into evidence, and feel free, if you want to listen to that again back in the jury room. First, the defendant stayed inside the house. He didn't try and help Brenda. He didn't call 911, even though his cell phone was on his person. Remember? It was in his pocket. We saw it on the body cam. But he told Officer Smith in the cruiser cam video that he couldn't find his phone. That was Exhibit 12. Remember Exhibit 10, the cruiser cam facing forward? The defendant was upstairs looking out the window when the police arrived. And then he came out with his hands up. Again, Exhibit 10. He wasn't waving down anyone for help. The house was on fire. He wasn't asking the neighbor, Dennis Williams, for help. He wasn't asking the police for help. He wasn't asking the paramedics or fire for help. No one. Again, things you could think of or consider for purpose. You heard evidence that he told paramedic Berter, I didn't mean to do it, but then he told Officer Smith and Sergeant McCroskey something totally different. He told Officer Smith he put his coat on to put out the fire, yet the coat was positive for an ignitable liquid, as well as his clothes. And initially he told Officer Smith he was trying to help Brenda, but then later said he didn't even know where she was, or he didn't even know if she was in the bedroom. Again, just some things you can think of or discuss if you want when you're back in the jury room when it comes to whether the defendant was acting in a purposeful manner. Going to purposely cause the death. Let's talk about cause the death. Dr. Schott testified that even though the death of Brenda Scott did not occur until June the 9th, 2023, it was because of the thermal injuries of head, torso, and extremities that caused the death. And thus the state submits to you the cause of death was the aggravated arson. It was the thermal injuries that eventually caused the death 29 days later. She said the manner of death was homicide, and obviously the deceased was Brenda Scott. So did Robbie Robinson purposely cause the death of Brenda Scott by means or while committing the offense of aggravated arson? I would submit to you that yes, he did, and that was proven beyond a reasonable doubt. So we have one last piece that the state needed to prove to you beyond a reasonable doubt, and that is what is called a specification to count one. And that is what is called the principal offender. I'll read it to you. If you find the defendant guilty of aggravated murder, so if you don't find him guilty of aggravated murder, you stop, you don't have to think about the specification. If you do find him guilty of the aggravated murder, then you go on and you think about the specification. You guys deliberate on that. All right? And what you then do is you think, all right, if you find him guilty of the aggravated murder, then you think, did the state prove beyond a reasonable doubt that the aggravated murder was committed while the defendant was committing the aggravated arson and he was the principal offender in the commission of the aggravated murder? Well, what does that mean? What is a principal offender? And that will be defined to you as such. A person is a principal offender when he was the actual killer and personally performed every act constituting the offense charged. There wasn't a co-defendant, there wasn't somebody else assisting. He did it all. He did it all. And again, I would say the state has proven to you he was the sole actor. He did do it all. You have Exhibit 3, the ring camera. He set me on fire. He set me on fire. Not they. Not multiple. He. 911. Sent her boyfriend's son for gas on her. His name is Robbie, 24 years old. He's still in there. Not multiple people. Not a they. He, his. Robbie. One person. Stebbins, cruiser cam, body cam. My apologies. State's Exhibit 4. The defendant himself said he is the only other person in there, other than Brenda. The defendant's own admission is that he was the only other person in there. Paramedic Berter. The defendant said, he himself indicated, I didn't mean to do it. Whether it's true or not, but I didn't mean to do it. Whether he's changed his mind or not, when he was then back in the back of a cruiser, his first statement was, I didn't mean to do it. Berter then testifies that Brenda tells him he punched her in the face and set her on fire. Again, Brenda is saying, in the singular, one person, the defendant, did these things to her. Then you have the processing photos of the defendant with the soot and the stuff on his hands. on the top, on the palms, and the blisters or the bubbles. Take it for what it's worth, but it's on his hands. Even after he got cleaned up after his printing, right, his fingerprinting, even after it's cleaned up, he has some markings on his hands, either from punching or fire. He has markings. And let us not forget the ignitable liquids on
the theme here in the closing argument, okay? There are facts.
Ladies and gentlemen of the jury, we're going to take a short break. When we return, the court's going to read to you the jury instructions. With any luck, the jury instructions will also appear on the screen simultaneously as I'm reading them to you. During the course of our break, do not discuss this case amongst yourselves, permit anyone to discuss it with you in your presence. Remember and abide by all the admonitions that I shared with you. All rise to excuse the jurors. Please have a seat. Ladies and gentlemen of the gallery, anyone who would like to leave, I appreciate you waiting until after the jury was excused. Thank you. You may take your leave now if you wish. Counsel, is there anything that we need to discuss
Yes, sir.
at this stage? Very well. Court passed out a fresh copy of the jury instructions, the final version of the jury instructions. They'll be presented to the jury. With that, we'll stand in recess.
Thank you.
be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts by direct evidence from which you may reasonably infer other related or connected facts, which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may, but are not required to, make from other facts which you find to have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. A fictional set of facts to illustrate direct and circumstantial evidence is as follows. A witness testifies that he saw two persons enter a cabin in the woods and only saw one come out. This is direct evidence of what the person observed. Another witness says that she did not actually see anyone enter or leave the cabin, but she observed two sets of footprints in the snow leading to the door of the cabin and one set of footprints leading away from the door of the cabin. This is evidence of circumstances from which the jury could reasonably, but not necessarily infer, that two persons entered the cabin and one person left. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated by you as though you never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer to that question might have been. You must not draw any inference from or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts and the weight of the evidence. To weigh the evidence, you must consider the credibility, that is, the believability of the witnesses. You will use the test of truthfulness which you use in your daily lives. There are several tests of truthfulness, one of which is the bias or interest, if any, of a witness. That is, if a witness has a personal, philosophical, or financial interest in the outcome of a case, that fact can be considered in determining the weight to be given to that witness's testimony. Other tests of truthfulness which you will consider include the appearance of each witness upon the stand, his or her manner of testifying, the intelligence of the witness, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which he or she testified, his or her accuracy of memory, frankness or lack of it, together with all the facts and circumstances surrounding the testimony. Apply these tests and assign the weight you deem proper to the testimony of each witness. You are not required to believe the testimony of any witness simply because he or she was under an oath. You may believe or disbelieve all or part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of that issue. Rather, the final test in judging evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness, believed by you, is sufficient to prove any fact. If there are discrepancies in a witness's testimony, or between any witness's testimony and the testimony of other witnesses, this does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them differently after the passage of time. You are all certainly aware that two persons who are witnesses to an event may see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether that discrepancy concerns an important fact or a trivial one. Should you, in the course of your deliberations, conclude that any witness has intentionally testified falsely to a material fact, you are free to disregard all of that witness's testimony on the principle that one who testifies falsely as to one material fact may also testify falsely as to other facts. You are not required circumstances to consider such a witness unworthy of your belief, rather unworthy of belief. You may accept as much of the testimony of that witness as you believe to be true, and reject only that part which you conclude is false. Generally, a witness may not express an opinion. However, one who follows a profession or a special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of an expert. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. You must not consider the fact that he did not testify for any purpose. The defendant is charged with aggravated murder in count 1 in violation of Ohio Revised Code section 2903.01b, an unclassified felony. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of May, 2023, and in Butler County, Ohio, the defendant purposely caused the death of another while committing or attempting to commit the offense of aggravated arson, as defined alternatively in counts 2 and 3. Purpose is an essential element of the offense of aggravated murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of another while committing or attempting to commit the offense of aggravated arson. Purpose is the decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself, unless he expresses it to others or indicates it by his conduct. The purpose with which a person brings about a result is determined from the manner in which it is done, the means or weapon used, and all other facts and circumstances in evidence. If a wound is inflicted upon a person with a deadly weapon in a manner calculated to destroy life, the purpose to cause death may be, but is not required to be, inferred from the use of the weapon. The inference, if made, is not conclusive. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon, or possessed, carried, or used as a weapon. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another, and without which it would not have occurred. While committing or attempting to commit means the death must occur as part of the acts leading up to or occurring during or immediately after the commission of aggravated arson, and that the death was directly associated with the commission of aggravated arson. The term while does not indicate that the killing must occur at the same instant as defined as purposely engaging in conduct which, if successful, would constitute or result in the commission of the offense of aggravated arson. A criminal attempt is when one purposely does or fails to do anything which is an act or omission constituting a substantial step in a course of conduct planned to culminate in his commission of a crime. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose. The offense of aggravated arson is defined alternatively in counts 2 and or 3 below. Before you can find the defendant guilty of aggravated murder, as charged in count 1, you must find by proof beyond a reasonable doubt that the defendant is guilty of committing each and every element of the offense of aggravated arson as charged in either count 2 or 3 or both. If you find the defendant, Robbie Devon Robinson, guilty of aggravated murder as charged in count 1, it is your duty to deliberate further and decide whether the state has proved beyond a reasonable doubt that the defendant is guilty of an additional factual question, which is called a specification. Your finding or verdict on this additional question will be expressed by a verdict of guilty or not guilty. Guilt must be proved beyond a reasonable doubt. If you find the defendant not guilty of aggravated murder as charged in count 1, you will not consider or decide this separate question. In the specification of count 1, you must decide whether the state proved beyond a reasonable doubt that the aggravated murder was committed while the defendant was committing or attempting to commit the offense of aggravated arson, and the defendant was the principal offender in the commission of the aggravated murder pursuant to Ohio Revised Code section 2929.04A7. The offense of aggravated arson is defined alternatively in counts 2 and 3 below. In order to find the defendant was the principal offender in the aggravated murder, you must find that he personally performed every act constituting the offense charged, while has previously been defined. The defendant is charged with aggravated arson in violation of Ohio Revised Code section 2909.02A1 in count 2 of the indictment, a felony of the first degree. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of May 2023 in Butler County, Ohio, the defendant, by means of fire, knowingly created a substantial risk of serious physical harm to any person other than himself. The person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result. The person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that the person is aware of the existence of facts and that his acts will probably be of a certain nature. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he created a substantial risk of serious physical harm to any person other than himself. Substantial risk means a strong possibility as contrasted with a remote or even significant possibility that a certain result may occur or that certain circumstances may exist. Serious physical harm to persons means any of the following. A, any physical harm that carries a substantial risk of death. Substantial risk means a strong possibility as contrasted with a remote or even significant possibility that a certain result may occur or that certain circumstances may exist. Excuse me. B, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. C, any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement. D, any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. The defendant is charged with aggravated arson in violation of Ohio Revised Code, Section 2909.02A2, in count 3 of the indictment, second-degree felony. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of May, 2023, and in Butler County, Ohio, the defendant, by means of fire, knowingly caused physical harm to an occupied structure. Knowingly has previously been defined. Because you cannot look into the mind of another, knowledge is determined from the facts and circumstances, rather all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he caused physical harm to any occupied structure. The state charges that the act of the defendant caused physical harm to property. Causes an essential element of the offense. Causes an act or failure to act that in a natural and continuous sequence directly produces the physical harm to property, and without which it would not have occurred. The defendant's responsibility is not limited to the most immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences or result that follow in the ordinary course of events from the act. Physical harm to property means any tangible or intangible damage to property that in any degree results in loss to its value or interferes with its use or enjoyment. Physical harm to property does not include wear and tear occasioned by normal use. Occupied structure means any house, building, outbuilding, or other structure, or any portion thereof, A, which is maintained as a permanent or temporary dwelling, even though it is temporarily unoccupied and whether or not any person is actually present, or B, which at the time is occupied as the permanent or temporary habitation of any person, whether or not any person is actually present, or C, in which at the time any person is present or likely to be present. The defendant is charged with felonious assault in violation of Ohio Revised Code, Section 2903.11A1, in count 4 of the indictment, a second-degree felony. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of May, 2023, in Butler County, Ohio, the defendant knowingly caused serious physical harm to Brenda Scott, to wit, her teeth. Knowingly has previously been defined. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he caused serious physical harm to Brenda Scott. cause has previously been defined. Serious physical harm to persons has previously been defined. In count 5, the defendant is charged with felonious assault in violation of Ohio Revised Code Section 2903.11A1. In count 5 of the indictment, the second-degree felony. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 11th day of May, 2023, and in Butler County, Ohio, the defendant knowingly caused serious physical harm to Brenda Scott, to wit, Burns. Knowingly has previously been defined. Cause has previously been defined. Serious physical harm to persons has previously been defined. If you find the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts of the indictment or the specification, your verdict must be guilty as to such offense or offenses or specification according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts of the indictment or the specification, your verdict must be not guilty as to such offense or offenses or specification according to your findings. The charges set forth in each count of the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately. Then you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or more of the offenses charged. The specification associated with count 1 of the indictment constitutes a separate and distinct matter. You must consider the specification and the evidence applicable to the specification separately. During your deliberations, you may not discuss or consider the subject of punishment. Your duty is confined to the determination or the guilt or innocence of the defendant and to the determination of any additional findings that may be submitted to you. At this time, you may not discuss the subject of punishment. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If, during the course of the trial, the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. You'll be provided with multiple copies of these instructions. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to express immediately a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide you are wrong. Consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. If during your deliberations you have a question, the foreperson must put your question in writing, stating specifically what is requested. That communication must then be delivered to the bailiff. You You've been permitted but not required to take notes during the trial. You'll recall that I instruct you prior to distributing the notepads that the decision to take notes is purely a personal one for each individual juror, based upon the individual habit and preference. As I said at the beginning of the trial, note-taking does not make a juror necessarily a more careful auditor of the testimony or a better observer of a witness's demeanor. Obviously, the notes of individual jurors are not in any way to be considered verbatim records of the testimony. It cannot be overemphasized that an individual juror's notes are just memory aids for that particular juror. Those of you selected as alternate jurors to serve on this jury panel must remain and be sequestered until the jury has returned its verdict in open court. A juror selected as an alternate is not permitted to participate in the jury's deliberations unless one of the deliberating jurors is found by the court to be unable or disqualified to perform his or her duties. You will be taken into a second location apart from the other jurors and will remain under the direction of the bailiff until the verdict is reached. The alternate jurors will not accompany the jury to the jury room or participate in the deliberations unless directed by this court. The alternate jurors continue to be part of the jury panel while the other jurors are deliberating until fully released from this case by the court. Alternate jurors are not required to follow. Strike that. Alternate jurors are required to follow all the court's orders concerning the conduct of the jury. You shall not discuss this case with anyone or each other or tell anyone how you would have voted until you were fully released from the case by the court. First order of business in the jury room will be to select from one of your number a person to serve as the foreperson. The court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these materials and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose the status of your deliberations or the nature of your verdict with anyone else. Ladies and gentlemen of the jury, back in the jury room, you will have the evidence that's been admitted in. It's been admitted. And you will also have verdict forms. There they are. All right. Each verdict form has the caption of the case. It appears on the screen. See if we can make it bigger. First one says verdict count 1. And in the body it reads, we the jury being duly impaneled find the defendant Robbie Devon Robinson. And then there's an asterisk. Blank line. And then after that, in parentheses, it reads, insert either guilty beyond a reasonable doubt or not guilty of aggravated murder in violation violation of Ohio Revised Code Section 2903.01B as charged in count 1 of the indictment, an unclassified felony. And then below that are 12 signature lines, one for each juror who is in agreement with that verdict that you've reached. Ladies and gentlemen, after you've deliberated on each count of the indictment, and should you get to it, the specification, once all 12 jurors are in agreement with your verdict, insert on the line provided the words guilty beyond a reasonable doubt or the words not guilty in accordance with your findings. All 12 jurors must then sign the verdict forms. Repeat that process for each verdict, for each count. I'll remind you that appears on your screen as specification count 1. It advises you right here where I've got the marker at the bottom of the verdict for count 1. If your verdict is guilty, you will separately determine the additional specification 1. If your verdict is not guilty, you will not decide this issue. So the specification for count 1 will deserve your consideration if and only if the defendant is found guilty with respect to count 1. As showing on the screen, there's a verdict form for count 2, a verdict form for count 3, a verdict form for count 4, and a verdict form for count 5. All of them are laid out in the same fashion. You have the caption of the case, they describe what, each describes what verdict count it deals with, which count it applies to. So you will have those verdict forms back in the jury room. All right, ladies and gentlemen, if you'll excuse us for just a moment, I'm going to ask counsel to approach. And I will return. Ladies and gentlemen of the jury, whenever all 12, I repeat, all 12 jurors agree upon a verdict, you will sign the verdict forms in ink and advise the bailiff. Will then be returned to the courtroom. You may now retire and begin your deliberations. So I'm going to ask that our 4 alternate jurors, would you step forward into the well of the courtroom just to give access to the other jurors so they can exit notepads with them, and at this time, move to the jury room. All rise to excuse the jury. Would you ask Ken to come to the podium, please? Ken Reynolds, the secretary. Deputy Bailiff Kim Reynolds, would you accompany the four alternates down to the magistrate's courtroom where the four alternates will remain, and all the admonitions that I've given to you continue to apply. You may not discuss this case amongst yourselves, or permit anyone to discuss it with you or in your presence. Is that understood? Thank you very much for your participation and your cooperation. With that, we'll have Ms. Reynolds take our four alternates down to the magistrate's room. All right, the record will reflect that the jurors have, including the alternates, have all vacated the courtroom. Counsel and the defendant remain present. Is there anything that we need to discuss before we recess pending the jury's verdict?
Not on behalf of the defense.
Very well, please. With that, then we'll stand in recess pending the verdict by the jury. Thank you.
You wish me to stand or stay seated,
So
sir?
you can stay seated.
We have reached a verdict, Your Honor.
Have all 12 jurors signed the verdict forms?
All 12 jurors have signed the verdict form.
Would you kindly hand the verdict forms to Mr. Laguna? Mr. Laguna, we'll hand those to the court this time. Thank you very much. All right, I'm going to address a series of questions to our 12 jurors at this time. And I ask that you raise your hand as your response if you have an affirmative response. Is there any one of you amongst the 12 regular jurors who did not follow the court's instructions and admonitions while you were deliberating? No one's raised their hand. Did any of you have outside contact, influence, or communication during the time the jury was deliberating? If so, raise your hand. For the record, no one's raised their hand. Has anyone other than the 12 deliberating jurors done anything, said anything, or in any way attempted to influence your verdict? No one's raised their hand. Has anyone, other than the 12 deliberating jurors, participated in any way in your deliberations, other than the 12 jurors? No one's raised their hand. This time, the court will review the verdict forms. This time, the court will read the verdicts. Is the defendant comfortable standing up? Very well. In the matter of State of Ohio versus Robbie Devon Robinson, CR 23050688. Verdict count 1. We, the jury, being duly impaneled, find the defendant, Robbie Devon Robinson, guilty beyond a reasonable doubt of aggravated murder in violation of Ohio Revised Code Section 2903.01B, as charged in count 1 of the indictment, an unclassified felony. In the matter of State of Ohio versus Robbie Devon Robinson, specification count 1, we, the jury, being duly impaneled, having found the defendant, Robbie Devon Robinson, guilty of aggravated murder as charged in count 1, guilty beyond a reasonable doubt of specification, to wit, that the aggravated murder was committed while the defendant was committing or attempting to commit the offense of aggravated arson, and the defendant was the principal offender in the commission of the aggravated murder pursuant to Ohio Revised Code Section 2929.04A7. Verdict was signed by all 12 jurors. Verdict form count 2 in the matter of State of Ohio versus Robbie Devon Robinson. We, the jury, being duly impaneled, find the defendant, Robbie Devon Robinson, guilty beyond a reasonable doubt of aggravated arson in violation of Revised Code Section 2909.02A1 as charged in count 2 of the indictment, a felony of the first degree. The matter of State of Ohio versus Robbie Devon Robinson, verdict count 3. We, the jury, being duly impaneled, find the defendant, Robbie Devon Robinson, guilty beyond a reasonable doubt of aggravated arson in violation of Ohio Revised Code Section 2909.02A2 as charged in count 3 of the indictment, a felony of the second degree. The matter of State of Ohio versus Robbie Devon Robinson, verdict count 4. We, the jury, being duly impaneled, find the defendant, Robbie Devon Robinson, guilty beyond a reasonable doubt of felonious assault in violation of Ohio Revised Code Section 2903.11A1 as charged in count 4 of the indictment, a felony of the second degree. Signed by all 12 jurors. Verdict count 5 in the matter of State of Ohio versus Robbie Devon Robinson. We, the jury, being duly impaneled, find the defendant, Robbie Devon Robinson, guilty beyond a reasonable doubt of felonious assault in violation of Ohio Revised Code Section 2903.11A1 as charged in count 5 of the indictment, a felony of the second degree. Signed by all 12 jurors. Ladies and gentlemen, stay right where you are, please. At this time, I'm going to ask counsel to please come forward. The defendant may have a seat. Counsel, sidebar. Play the music, please. The the specification as to count one. The jury wrote in guilty beyond a reasonable doubt, but in front of that phrase, normally the verdict form would say, "do hereby find." In other words, the jury do hereby find. So the court is going to revise the verdict form. It's pretty clear to the court, very clear to the court, quite frankly, what your finding is. But so that there are no questions, I'm going to send this and all the verdict forms back into the jury room. I'm going to revise the verdict form as to the specification so it reads grammatically correct. Would ask that you continue your deliberations and complete all the jury verdict forms in accordance with those deliberations. Does raise your hand if any of the 12 jurors have any questions about what is being asked of you at this time? No one's raising their hand. Mr. Laguna, I'm going to hand the verdict forms back to you. I'm going to ask that you return them to juror number 75. Our 4 alternate jurors will return to the magistrate's courtroom. Our 12 jurors will be excused to the jury room at this time. Counsel, have any questions or concerns you wish to bring to the court's attention?
No, sir.
All rise to excuse our jury. number 75, are you still the foreperson?
I still am, Your Honor.
Has the jury completed and signed all the verdict forms at this stage?
Yes, Your Honor.
Would you kindly hand the verdict forms to Mr. Laguna? Counsel's welcome to have a seat if they'd like, and the defendant as well. The verdict forms are just as the court previously read, all signed by all 12 jurors, finding the defendant guilty as to each and every count 1, 2, 3, 4, and 5. The court made an error on the specification count 1 in the language, whereas the court failed to include before the line provided for the jury to write in guilty or not guilty, failed to include the phrase, find the defendant, Robbie Devon Robinson, and then the blank line for the jury to fill in guilty or not guilty. So at this time, the court's going to read the revised, the corrected specification count 1. The defendant can remain seated. We, the jury, being duly impaneled, find the defendant, Robbie Devon Robinson, guilty of aggravated murder as charged in count 1. Find the defendant, Robbie Devon Robinson, guilty beyond a reasonable doubt. Of the specification, to wit, that the aggravated murder was committed while the defendant was committing or attempting to commit the offense of aggravated arson, and the defendant was the principal offender in the commission of the aggravated murder pursuant to Ohio Revised Code, Section 2929.04A7, signed by all 12 jurors. It's the court's intention to pull the jurors at this time. Does counsel wish to be heard or believe that there are any questions as to what the verdicts, the jury's verdicts are as read by the court, including the corrected verdict form for the specification? State says no.
Yes, sir.
Defense says no. Of our 12 jurors, ladies and gentlemen, at this stage, the court's going to ask each of you a question. We call that polling the jury, all right? Actually, I'm going to ask you more than one question. So I'll start with seat 1, which is juror number 2. Hello? Did you hear the verdict that was read here in the courtroom to the 5 counts and the specification? Is that the verdict of the jury? Is that your individual verdict as to each count and the specification in this case? Juror number 4, same questions. Did you hear the verdict as read here in the courtroom? Do those represent the verdict of the jury? Yes. Is that your individual verdict as to each of the 5 counts in the specification? Yes, sir. Juror number 6. Did you hear the verdicts as read here in the courtroom?
Yes.
Do and the specification in this case?
Yes.
Juror number 9, did you hear the verdict that was read here in the courtroom? Is that the verdict of the jury?
Yes.
Is that your individual verdict as to each of the 5 counts as well as the specification in this case?
It is.
Juror number 22, did you hear the verdict that was read, the verdicts that were read here in this courtroom?
I did.
Is that the verdict of the jury?
It is.
Is that your individual verdict as to each of the 5 counts as well as the specification in this case?
Yes.
Juror number 28, did you hear the verdicts as read here in open court?
Yes, Your Honor.
Is that your verdict?
It is.
I'm start that. Is that the verdict of the jury?
It is.
It is. Is that your individual verdicts as to each of the 5 counts as well as the specification in this case?
Yes, sir.
Juror number 29, did you hear the verdicts as they were read here in open court?
Yes.
Is that the verdict of the jury?
Yes.
Is that your individual verdict as to each of the 5 counts as well as the specification in this case?
Yes.
Juror number 37, did you hear the verdicts as read here in open court?
I did.
Is that the verdict of the jury?
Yes.
Is that your individual verdict as to each count of the indictment as well as the specification in this case?
Yes.
Juror number 61, is that you, sir? I skipped one. Juror number 46. Thank you. Did you hear the verdicts that were read here in open court?
Yes, I did.
Is that the verdict of the jury?
Yes, it is.
Is that your individual verdict as to each of the 5 counts as well as the specification in this case?
Yes, it is.
Now, juror number 61, did you hear the verdicts that were read here in open court?
Yes, sir.
Is that the verdict of the jury?
Yes.
Is that your individual verdict as to each of the 5 counts in the indictment as well as the specification in this case?
Yes, sir.
Juror number 75, did you hear the verdicts as was read here in open court?
Yes, Your Honor.
Is that the verdict of the jury?
Yes, Your Honor.
Is that your individual verdict as to each of the 5 counts as well as the specification in this case?
Yes, Your Honor.
Juror number 92, did you hear the verdicts as were read here in open court?
Yes, I did.
Is that the verdict of the jury?
It is.
Is that your individual verdict as to each of the 5 counts of the indictment as well as the specification in this case?
Yes.
Thank you. going to address a series of questions to our four alternates. All right? Alternate number one, juror number 93. Did you hear the verdict of the jury in this case?
Yes.
You accept the verdict of the jury in the event that it is necessary for you to participate in the deliberations and render a verdict in the next phase of the trial. Speak up, please.
Yes.
Thank you. Alternate number two, juror number 102, did you hear the verdict of the jury?
Yes, sir.
You accept the verdict of the jury in the event that it is necessary for you to participate in the deliberations and to render a verdict in the next phase of the trial.
Yes, sir.
Alternate number three, juror number 110, did you hear the verdict of the jury?
Yes.
You accept the verdict of the jury in the event that it is necessary for you to participate in deliberations and to render a verdict in the next phase of the trial?
Yes.
Thank you. Juror number 111, who's alternate number 4. Same questions. Did you hear the verdict of the jury?
Yes.
You accept the verdict of the jury in the event it is necessary for you to participate in deliberations and to render a verdict in the next phase of the trial?
Yes.
Very well. Counsel, it's the intent of the court this time to dismiss the jurors until next week. Before I dismiss the jurors, first off, is both the state of Ohio and the defendant satisfied with the polling of the jury in this case?
Yes, sir.
Yes, sir.
Is there anything that you wish to bring to the court's attention before I release the jury from their duties as it relates to phase one of this trial? The state says no.
No, sir.
Shaking your head no.
No, sir.
Thank you. That says no. Ladies and gentlemen, at this time, you're going to be released from sequestration. That means you'll be returning home, give you back your cell phones. However, the trial's not over. So you continue to be bound by the original instructions and admonitions which we previously discussed. It will be necessary for us to move to a second stage of this trial. This is known as the sentencing phase. The procedure of the trial is very much the same. We will have opening statements, evidence, closing arguments, instructions, and deliberations. Before we move to the next stage of the trial, we're going to take a few days off. You're going to be ordered to return here next Tuesday. Tuesday, thank you, February 18th. At 8:45 a.m., we'll get started at 9 o'clock a.m. There's a good chance that the jury will get the case on Tuesday. So I'm going to ask that you bring your overnight bag and follow the same protocol that you followed today. In the event the jury is deliberating and needs to stay overnight, you'll have your overnight bag. So bring that with you on Tuesday and make those arrangements. admonitions are gonna continue to apply. So we come back here next Tuesday. And thereafter until you're released, each and every one of you, including our 4 alternates. Do not discuss this case with anyone or permit anyone to discuss it with you or in your presence. Do not talk with the attorneys, parties, or witnesses in this case. If anyone should attempt to speak to you about this case, please report that to Mr. Labuno immediately. Do not attempt to investigate or attempt to obtain additional information about this case on your own. Do not read, view, or listen to any report in the newspaper, radio, television, internet on the subject of this trial. Do not permit anyone to read, view, or comment on them or it in your presence. Do not communicate any aspect of this case on any blog or social networking site such as Facebook or Twitter. When you return on Tuesday, you'll report to the magistrate's courtroom, the same process that we used all last week and that we used this morning, and we'll use it next Tuesday. Of course, at this point in time, you understand, and following this order, do not enter the courtroom except as a group when accompanied by and invited by Mr. Labuno. So report directly to the magistrate's room, and Mr. Labuno will bring you as a group here to the courtroom. All these orders apply to all 12 of our regular jurors, including our 4 alternates. The court and the parties and the community thanks you for your service. Thank you. It's clear that you're taking your duties seriously. I know it's an imposition, I know it's a sacrifice. Let's continue to work on serving with honor and distinction so that this could be a source of pride all your living days of the service that you rendered to the justice system in your community. So I do thank you. Now, do any of our 12 jurors have any questions? Or no, not just our 12 jurors, our 12 jurors and our 4 alternates. Do any of you folks have questions? All right, before Mr. Labuno is going to escort you back to the magistrate's room, so I'll give you back your cell phones. We'll have your overnight bags, and you will be excused from your service, except for all the admonitions I shared with you, until next Tuesday morning, February 18th, 8:45. Mr. Labuno, have I forgotten anything?
No, Your Honor, but I'd like to add, please leave your badges on your chairs. We will hold your notepads, since they all have numbers on them. We will hold them in case you need them later.
I'm going to discuss it with the attorneys, but I imagine you may receive fresh notepads on Tuesday morning. So, we'll work that out. I'll work that out with the attorneys and let you know. All right? Very well. Counsel, have anything else for the jurors between now and next Tuesday?
No, sir.
Very well. All rise to excuse our jurors. Thank you, ladies and gentlemen. Thank you very much. All right, please have a seat. The jury has been excused. Counsel and the defendant remain here in the courtroom. Court, of course, will accept the verdicts, we'll sign them, and they'll be filed with the clerk of court's office. To be clear, the defendant was present here in the courtroom while the verdicts were read here in open court. Did the defendant hear and understand the verdicts as they were announced here in open court?
Yes, sir.
The defendant has indicated yes. All right, we're now going to move to the sentencing phase of the trial. The court wishes to advise the defendant that he has the right to a pre-sentence investigation report being prepared. If you elect to have a pre-sentence investigation report, it can be used by the jury in reaching their verdict as to the sentence. Does counsel wish, on behalf of the defendant, to waive his right to a PSI, or do you need more time to talk to him about this?
Judge, we will waive the PSI.
Thank you. The defendant is advised that he has the right to a mental examination. If you elect to have a mental examination, it can be used by the jury in reaching their verdict. Counsel, does the defendant wish to waive his right to an examination, or do you need more time to talk to him about that?
Well, Judge, I think the proper way to answer that is we do not need another mental examination. As the court is aware, we've had several in this particular case. We've produced one as a product of discovery leading up to this particular case that we intend on using in the sentencing phase. We do not need another one at this point.
Very well. So the statute provides for yet another one to be prepared at the election of the defendant, and at this time the defendant's waiving that right, correct?
Yes, sir.
Thank you. The defendant is advised that he will have many of the same rights in the sentencing phase as he did in the trial phase. Of course, he'll have the right to present evidence and to call witnesses. The defendant's further advised that he has the right to speak at the sentencing phase if the defendant wishes. In that regard, the defendant has three options. You can testify under oath. If you testify, the prosecutor will have the opportunity to cross-examine you. Secondly, the second option, you can make an unsworn statement. This statement is not conducted in a question and answer format, but you have a chance to tell the jury whatever you would like. The prosecutor cannot cross-examine you, although the prosecutor's office will be allowed to point out to the jury that you were not sworn in like the rest of the witnesses. Third option is that you can remain silent. Do you understand your rights?
Yes, sir.
All right. I would propose maybe Thursday afternoon that counsel and the defendant and the court get together and talk about what evidence is going to be presented, unless the state's prepared to talk about it now. What evidence the state intends to present for the sentencing phase. Let's do it on Thursday. I'm gonna have to do a little research, but I think it's just state agrees.
The state
Let's
agrees,
put it
that's
that way.
easier to say.
Thank you.
No objection from the defense with
No
regard to
objection
the
from the defense.
What
Let me see what, let's
time
see
on
what our
Thursday?
schedule looks like Thursday afternoon. All right, maybe 2 o'clock on Thursday?
Judge, is it possible to do 3 o'clock on Thursday?
That's fine. I don't think it's gonna take a long time, I just thought we ought to have I'd like to have everything ready to go on Tuesday morning so that we're not delayed hashing some kind of legal question out. I may